So thanks very much for inviting me. This is my first originalism conference, so it's been very enjoyable so far just to see how these things work. So I think this is a wonderful paper, a great project. I think the authors put forward a lot of really powerful evidence that due process of law had a narrow meaning involving service of process. I think they do a great job walking us through a tremendous amount of history and making it clear. It was a fun read. You guys also do a good job of recognizing when the historical evidence is either unclear or a bit against you. And I appreciate that. At least in the footnotes, you recognize that, and often in the text as well. And I appreciated that, as Larry always does, you do a great job explaining the methodology. So I think this is a fascinating paper. It got me thinking. I do have a number of comments. So as I said, I think you put forward a lot of powerful evidence that that due process of law was just about service of process. But I think you do run into the possibility of readers being very skeptical that that's the case, that things as important as life and liberty and property were just going to be protected by writs. That just seems a bit counterintuitive. Now, I think part of the challenge that you face comes from the way you frame your paper in the introduction. You frame this requirement as a, quote, narrow and technical one. I think you can say that it's a little bit less narrow and technical than you're talking about, because you are talking about notice, court-issued notice, and that seems not as narrow and technical and potentially pretty important. And you do provide this evidence of these writs being a way to guard against arbitrary executive infringement on rights. So I think I would be careful about using that narrow and technical language. Nonetheless, we're still talking about service of process, writs, as opposed to a much richer due process of law clause. And so that got me to thinking, well, let's suppose you're right, that that's all that due process of law means. Is it true that life, liberty, and property, that's really the only protection? You just get a writ, you get the notice. And so that got me thinking about the rest of the Constitution. And one of the things I'm going to suggest is that you talk about other provisions of the Constitution. So even if due process of law in the Fifth Amendment is as narrow as you say, you've still got the rest of the Fifth Amendment. So you've got the protections for a grand jury, the protections against self-incrimination. Sixth Amendment guarantees of speedy trial and an impartial jury, information about the nature of the charge, the right to confront accusers, and some kind of right to counsel, albeit not spelled out in the Sixth Amendment. Now, these are all things that apply to criminal trials, but of course your interpretation applies to the criminal or civil context. But you also have the Seventh Amendment that protects some kind of jury in cases at common law. And that would suggest that you have the procedural protections that lead to a jury trial, which presumably would involve some type of witnesses, some type of evidence, the things that juries need to decide cases. So I mention all that because I think if you're gonna make the argument for this interpretation, I think it's really important to point out the rest of the Constitution that might make it a bit more palatable to folks. Now, it still may not be palatable. And that leads me to the final framing point I have other points as well. This gets back to something that Gary said earlier. What is your burden of proof? And I think one challenge, of course, this is not a challenge that Gary would recognize, but one challenge is when you're going against stare decisis. Do you have a higher burden of proof on the historical evidence? Does the historical evidence not only need to be 51 to 49, but maybe more like 95 to 5 if you are challenging stare decisis in a substantial way? And I'm not taking a position on that. That's just something to think about. But also, when your interpretation does feel counterintuitive, do you have a higher burden of proof? Now, not everybody may find this to be counterintuitive, but to the extent that one finds to be counterintuitive, counter to the purpose of the provision, is the standard of proof higher? I am personally someone who believes in text, and I believe that texts can be counterintuitive or somewhat in tension with the underlying purpose. But when the text is, do you need to be really sure about what that text means? This is just all on the framing of the paper. My second set of comments is about the interpretive theory. As I said, you guys do a wonderful job explaining your interpretive methodology. Just following up on my earlier comments, you say in your paper that the text is ambiguous, due process is ambiguous, and the constitutional structure doesn't tell you very much. And one of the things I'm suggesting is, well, maybe it tells you a little bit more than you give it credit for. There actually are a lot of constitutional provisions that might make your interpretation more plausible. The second thing is about your use of corpus linguistics. I found this to be really interesting. The way that you set it out in the paper, you first look to the early dictionary definitions of process. You look just to the compulsory process provision. You could look to other portions of constitutional structure, I think. And you say only when those pieces of evidence don't tell you a lot should you look to corpus linguistics. And I'm wondering if you really do view that as an order of propriety and in terms of preferences on the interpretive method. Do you think that it is important to first look at the dictionary definition of those early terms, looking at contemporary dictionaries, then looking at constitutional text and structure, and only if you find those to be indeterminate should you look to corpus linguistics? So that's just a question about the methodology. And on a smaller point, I wondered about your use of corpus linguistics. So you found 6,754 results on the word process, and you looked at a random sample of 100 of them. That struck me as a reader as a small number of the 6,700, and maybe it's not in corpus linguistic circles, but you might want to say a bit about why, if that is an okay representative sample, why that is an okay representative sample. So just that's on the methodology. My final set of comments is about the normative implications. And by the way, I want to say that I've typed all of this up, so you don't need to write these comments down. I will send them to you. And I have a couple of like nitpicky things that I won't bother stating here. But so I think you do a very, very good job in many parts of your paper saying the normative implications here about the Fifth Amendment, not the 14th Amendment. And I think that's important. I do think on a small point, you need to be careful to say on page 5 that your paper has implications for international shoe, because of course international shoe is a 14th Amendment case. So just be cautious about saying that. When you get to the end of your paper, you're very careful to focus on the Fifth Amendment. Also be careful about suggesting, as you do on page 53, that this is about Lochner and Roe, which of course it's not. So just a couple of cautionary notes there. I do hope that you guys explore the implications for the 14th Amendment, because it seems like your interpretation could have tremendous implications for the 14th Amendment, that maybe the due process of law clause really did change in meaning by the time of the ratification of the 14th Amendment. And that could mean that states can't do a lot of things that the federal government actually can do. And that leads me to my final point about implications. I was wondering about equal protection. Of course, there is no equal protection clause in the Fifth Amendment. We all know that. But the Supreme Court has said that the 14th Amendment due process clause provides an equal protection principle that applies against the federal government. And so what implications does this interpretation have for that? Now, of course, I think all of us automatically think of Bowling versus Sharp, segregation of the District of Columbia schools. That could be a very important implication. I'm actually less concerned about that because I don't have any fears that the District of Columbia is going to resegregate the schools. What came to my mind was Adirond. Does your interpretation have implications for the equal protection component such that it actually impacts the federal government's ability, capacity in the context of affirmative action? And it made me think of cases like Metro Broadcasting versus FCC that said prior to Adirond that the federal government actually had a lot more leeway in the context of affirmative action than do the states. So just some things to think about. I will say that whatever one thinks of the merits, this is not an area I've looked at myself, so I don't have strong views on the merits. But whatever one thinks about the bottom line, this paper got me thinking, and for that reason alone, I thank you. I think it's a wonderful project, and I look forward to hearing more.
I'll say a few things, and then Matt, mostly about the methodological and implications issues raised by Tara in her wonderful comments. And then Max may have some more to add. So on the skepticism point, right? So I think this is fascinating. I think readers are going to be skeptical, and this is a demonstration of the power of linguistic drift. It's clear that the phrase due process of law now has a very different meaning, both legal meaning and ordinary meaning, than it did in 1791. So people come to the due process of law clause with assumptions based on contemporary linguistic meaning. So, but if you're an originalist, right, you need to be skeptical about contemporary linguistic intuitions, no matter how powerful they are. So I think one of the nice things about the paper is that it begins to tell the story about how this transformation occurred. I think there's a separate paper to be written on how the modern meaning came into being. I thank you. Regarding the jury provisions, we really should say that, even though we can add not one word. Every word we add to this paper means we have to subtract another word. And then on burden of proof, I think that's a really important question, but it's just not a question we're going to be able to address in this paper, because I have a theory of constitutional stare decisis and what the burden of persuasion ought to be in cases like this, but presentation of that theory, even in the sketchiest possible form, would add thousands of words, and really we just can't do that. So we have to bracket a lot, and that's one of the questions we have to bracket. Max?
Yeah, I mean, thank you so much for those comments. And just to start with the first, which is potentially the most important, you framed this as a comment on framing, but I think it really gets to the heart of the normative case that we're trying to make in this article, which is that the due process of law clause is narrower in many ways than people have understood, but it is also a powerful check on arbitrary power from at least the executive. And while we do comment on the notice power that this clause has, it also has traditionally had jurisdictional implications as well, which we mostly discuss in a part of the paper, or the historical evidence for which we mostly discuss in a part of the paper which was not assigned. But effectively, the purpose of the clause was to ensure that courts of law had jurisdiction over deprivations rather than the executive itself. And so I felt that was a really important point, and I want to thank you for bringing that out. As to the rest, I think Larry's already talked about the burden of proof. And I will say that the small corpus linguistics sample that you commented upon is absolutely my fault. We slightly ran out of time while we were conducting it, but I will say that from just anecdotally going through the corpus, and I would invite anyone else to do this themselves, this sample was not misrepresentative of the general trend of authority. And we will be expanding it in the actual published version of the article. So I'm conscious that I'm running out of time, but I do want to say thank you for your comments on the implications for affirmative action as well. This is a question that I've gotten. The implications on bowling is a question that I've received a fair amount while discussing this paper with others. And it's really exciting to see this other potential avenue in terms of implications for the paper as well. So once again, thank you so much. Those were such thoughtful questions. And I really look forward to receiving the full written report later on.